Righting wrongs here at Hudgell Solicitors, the easy guide to legal issues many people may have to deal with in their lives. I'm Keith Phillips, and joining me is medical negligence solicitor Amy Rossall. Welcome, Amy.
Hi, Keith.
Now, Amy, one aspect of medical negligence you specialise in is representing families where a loved one has taken their own life, died by suicide, while receiving psychiatric care.
Yes, when a person is a threat to their own health or to that of others, they can be detained under the Mental Health Act. The aim of this is to provide them with treatment to aid their successful recovery. But in many cases, we see failures in the care provided, which sadly leads to people taking their own life.
And this is in fact medical negligence, and claims can be brought.
Yeah, that's correct.
Now, Amy, these are tragic and heartbreaking circumstances for families. Could you explain how these suicides could have been prevented? I mean, what are the failures? What is the negligence in care that you come across?
In some of the cases that we have represented the bereaved families, we come across many types of failures. Some of those failures include a failure to undertake appropriate observations and checks of the patient, a failure to undertake the correct risk assessment, which can be a contributory factor to someone sadly taking their own life, suicide after a misdiagnosis of a mental health illness, or of mistreatment of a mental health illness, failure to place them in a safe environment, discharging them before they're actually ready to be discharged, and also failures to consult with the family prior to release.
Amy, if someone should take their own life while they're under specialist care, families will often want answers about how it was allowed to happen. I mean, how do they get comprehensive, meaningful answers?
One of the first steps to obtaining answers for the families who have lost loved ones in this way is an inquest. It aims to answer 4 statutory questions, being who the deceased was and how, when and where they came about their death. It will investigate the cause of the death and the circumstances surrounding the death. In some cases, that the scope of the inquest can be widened.
And in cases where the scope of the inquest is widened, their death may be the focus of what's called an Article 2 inquest. This is a special kind of inquest.
Yes, Article 2 protects your right to life. An Article 2 inquest investigates whether appropriate steps have been taken to protect life, where there is an immediate and real risk, and whether there are appropriate systems in place to protect life. Article 2 can be engaged by the coroner, and it can be engaged whether the person is sectioned or detained under the Mental Health Act, if they are admitted to hospital for psychiatric care, whether that be voluntarily or involuntarily, whether they have recently been discharged, or whether they're under the care of the community mental health teams.
And holding an inquest into someone's death could prevent others taking their own lives in similar circumstances.
Yes, where there are failures identified, coroners can issue a report called a Prevention of Future Deaths report. The report deals with failures that have been identified, and it places responsibility on those involved in the care to implement changes to the way they work to prevent future deaths that could have been avoided.
Now, Amy, you're a medical negligence solicitor. Why are Article 2 inquests particularly important when it comes to medical negligence investigations?
Whilst the coroner cannot determine civil or criminal liability, the process of the questioning and the coroner's conclusions can prove supportive for legal proceedings, such as claims for compensation. We work hard to highlight any failures, and we can advise clients following conclusion of the inquest about any claim for compensation.
Well, Amy, if someone has lost their partner or their child to suicide while they were detained under the Mental Health Act or were under specialist mental health care, Why is it important they seek legal advice from a specialist solicitor like yourself?
We have lots of experience dealing with inquests and Article 2 inquests. We've represented clients where we have obtained significant findings of failures in the mental health care that their loved ones have been provided. The proceedings can be complex, and often the state bodies and organisations will have their own legal teams, and it's important that the families are supported by a solicitor who is specialist in these types of cases.
And families are entitled to legal representation at inquests, aren't they?
Yes, under the Coroners and Justice Act, interested persons are entitled to legal representation and to ask questions at inquests. Interested persons includes the family, that can be parents, children, spouses, partners.
Ultimately, it would be their choice whether they wanted a lawyer representing them?
Yes, that's correct. They can be complex, the coronial proceedings, and it's important that they make the decision as to whether they would like legal assistance to support them through the process.
Would families have to pay for legal representation themselves at inquest?
Depending on the circumstances, they may be eligible for state-funded representation, such as legal aid, or if that is not available or they're not eligible, then we may offer representation on a no-win, no-fee basis, but please do call us to discuss.
Thanks very much, Amy, for your expert advice. Amy Rossall, Medical Negligence Solicitor here at Hudgell Solicitors. Thanks for listening to Righting Wrongs, and if you need further information on any medical negligence issue, head to our website, hudgellsolicitors.co.uk.
Thank you.